Good Vach, Shavua Tov, a good week to you, my holy sisters and brothers. Great to be learning with you on a Saturday night. Let's light up the darkness. Who's in the house as we continue our journey through chapter 8, also known as Perek HaChovel, here in Tractate Bava Kamma, 21st volume of the Talmud. Our daf is Pei Daled, page 84. In the house is Bella in Florida, Shandor in the Bronx, Paul in the Great Northwest, Guy in Ohio, Joe in the Inland Empire, Ella's in the house, Sharon in New Jersey. Welcome, everybody. Okay, we made a good start on page 84, so we're, I think more than halfway down 84a. So we're continuing our discussion of MIshna number 1 here in chapter 8 of Tractate Bava Kamma. And the sages have been offering a bunch of different derivations. It's like they know that an eye for an eye in the Torah does not mean an eye for an eye. If somebody injures another person and happens to put out their eye, presumably this is accidental, but they do something on purpose. Maybe they didn't intend to cause the other person to lose an eye. Whatever the intention was, we're going to go in. We're going to make them pay. They're going to be liable for damages, monetary damages, not a situation where the court is going to step in and take out the eye, of the one who is liable. Now, the Torah seems to speak pretty clearly: an eye for an eye, a tooth for a tooth, a hand for a hand, a foot for a foot. So how is it that the sages can interpret this as meaning monetary damages? Now, understand that the sages are not rewriting the Torah. They're interpreting the Torah, right? And they're showing that what the Torah meant is that it would be paid in monetary damages. And a lot of different arguments have been offered. Among them, which is pretty convincing, that, for example, if it meant that the court would take out the eye of the person, who injured another and caused them to lose an eye, well, what if the one who lost an eye, was a surgeon who absolutely needed his vision, and the person who caused him to lose the eye had a job where, his perfect vision wasn't that important. I mean, taking out the eye of one doesn't make up for the loss of the other. What if the one who caused the injury is blind? He doesn't have an eye to give up. If we're going to have everyone equal under the law, but people are all different and you can't impose the law in an equal manner, it's definitely going to be problematic. And a bunch of other proofs were also offered. Some were accepted, some not. But you get the sense that it was known from the earliest of times that it meant monetary damages and not an actual eye for an eye. And they were just looking for the proof text in the Torah. Okay, so more than halfway down the page, on page 84a, we pick it up. So it is taught in a baraisa that Rabbi Eliezer says the verse that states an eye for an eye, Exodus 21:24, is referring to an actual eye. What? Does this mean that Rabbi Eliezer disagrees with the other sages? And the Gemara asks, can it enter your mind that the verse is referring to an actual eye? Doesn't Rabbi Eliezer understand the verse like all these Tanaim, all these rabbis of the MIshna that preceded him in this argument, and who explained that this verse is referring to a monetary payment? And Rabbah said in response that what Rabbi Eliezer means is to say that the court does not appraise the injured party as a slave to assess the compensation for the injury, right? We said that one of the ways that a court would assess damages when somebody is maimed in some way, like losing an eye, losing a tooth, losing a hand, losing an extremity, is that had they been sold as a slave in the slave market when slavery existed, and then they lost, this body part, how much would their value as a slave have been diminished? And that's one way to measure damages. Right, so now Rabba is saying that Rabbi Eliezer means to say that the court does not appraise the injured party as a slave to assess the compensation for the injury. So Abaye said to Rabba, well, rather, like whom does the court appraise the injured party? If you say that the court appraises him like a free man, does a free man have monetary value? Right? I mean, this idea of assessing value to a body part would be in relation to assessing value to a human being. You can't assess the value of a human being. It's very interesting. Okay, when slavery existed, okay, people bought and sold people, so there was some kind of economic indicator of what a person was worth, and then by extension what a body part would be worth. But that didn't apply to free people. Right? And so now that slavery is gone, thank God, at least it's gone from most of the world in any kind of legal manner. I think tragically there are some practices that are like slavery still existing in the world. But as an institution, thank God it's gone from this world. So then, like for all free people, how could you measure the worth of a person and assess a number? So what does this mean? If you say that the court appraises him like a free man, does a free man have monetary value? Rather, Rav Ashi said that what Rabbi Eliezer means to say is that the court does not appraise the injured party as if he were going to be sold as a slave, but rather they appraise the one who caused him the damage. You treat the one who caused the damage as if he was a slave. And why would you do that? Well, the court appraises how much the latter's value would be reduced were he to sustain the same injury that he caused to the injured party, and he pays this amount as indemnity. And that actually makes some sense, because what we were talking about is that one of the derivations is that if a person is guilty of murder, so he's subject to the death penalty, and he can't, just because he happens to be a wealthy person, pay his own value as a person to the family, let's say, of the murder victim as a ransom, so that he wouldn't have to give up his life by way of capital punishment. So the Torah specifies that you can't pay a ransom to get out of the death penalty. And what the sages read into that is you can't pay a ransom for the death of the whole body, but you can pay a ransom for the death of a limb. Meaning that if, God forbid, I injured somebody and caused him to lose his eye, and now the Torah says an eye for an eye, so now I would have to give up my eye, but instead of giving up my eye, I can pay the money. Right? So you can pay ransom for a body part, even though you can't pay ransom, kofer, for your life if you are guilty of murder and subject to the death penalty. And so whose value would you assess? The eye that was lost, or the eye that is being ransomed, as it were, the eye of the one who caused the injury? So that's what Rabbi Eliezer was saying. Now the Gemara relates, there was a certain donkey that severed the hand of a child. And the case came before Rav Papa Bar Shmuel. And he said to the officers of the court, go appraise the 4 types of indemnity for the child, right? Meaning the damage to the child, the loss of livelihood, the pain and suffering, and the medical expenses. And Rava said to him, but didn't we learn in the MIshna that there are 5 types of indemnity, which includes humiliation as well? And Rav Papa Bar Shmuel said to him, I was saying to include the indemnities the responsible party is liable to pay other than damage. So there's 5 altogether. And Abaye said to him, but was this not a donkey that caused this injury? And the owner of a donkey that causes injury pays only for the damage, right? So we learned this earlier in our journey through Bava Kamma, that when a human directly causes an injury to another person is when, in addition to the damage, there's the 4 types of indemnity. But when your animal that you own somehow, breaks free of its bonds and injures another person, you might be negligent, but the Torah doesn't mandate that you pay those additional forms of indemnity. You're only liable for the actual damage that was caused. And Rav Papa Bar Shmuel said to the officers of the court, go appraise for the child the value of his damage, meaning he hadn't been told that the damage to this child was caused by the animal. He thought it was caused by the person who is liable. And they said to him, but doesn't the child need to be appraised as a slave in order to assess the damage? And he said to them, yes, go appraise him as a slave. And the father of the child said to them, I do not want my child to be appraised as a slave, because this matter would demean him. And they said to the father, but you are acting to the detriment of the child, as he will not receive compensation for his injury. And he said to them, when he matures, I will appease him with my own money, rather than see him demeaned now through this appraisal as if he were a slave. And the Gemara relates another incident. There was a certain ox that chewed the hand of a child, injuring him. And the case came before Rava, and he said to the officers of the court, go appraise him as a slave. And they said to Rava, but wasn't it you, master, who said, with regard to anyone who is appraised as a slave in order to determine the amount of a monetary penalty, that penalty is not collected by courts in Babylonia, meaning the rabbinic courts in the Jewish community of Bava in Babylonia. And Rava said to them, it is not necessary to appraise his value in order to force the guilty party to pay restitution, but it nevertheless is necessary to determine his value. And this is because if the injured party seizes property from the one who caused him injury, and that property is equal in value to what the payment should be, the court will not compel him to return it. And in the discussion that follows now, we're going to see that there were limitations on what the courts in Babylonia could impose on people brought before the court as compared to rabbinic courts established in Eretz Yisroel, in the land of Israel. And by extension, what courts in Babylonia could do and not do is what modern courts, what rabbinic courts outside of Israel, not only then but now, can or cannot do. And what that's going to depend on is this is smicha. Now, today we still say that when a rabbi becomes a rabbi, he receives smicha, ordination. It literally means that putting the hands on, as like the rabbi from the previous generation ordains a rabbi in the new generation. So we still have ordination of rabbis, but when the Talmud is discussing ordination, they're talking about something specific and that is no longer available. And that was ordination by the sages in the land of Israel, who had kind of a direct chain of receiving ordination. You know, the sages from the elders, from the judges, from Joshua, from Moses. And sort of that level of ordination at a certain point was cut off. And so the result of that is that the rabbinic courts sort of in the diaspora, and again, you could see a little bit why this is happening, because, you know, when you're subject to the law of the land that you're living in, okay, so then the rabbinic court doesn't have the same kind of power and authority that it had when the great Sanhedrin was meeting in Yerushalayim, in Jerusalem, and the Jews had their king and had sovereignty over the land. That's another one of the differences. But at any rate, among the limitations of what rabbinic courts can and cannot do, as compared to these earlier courts that were ordained, is actually to collect payments that are understood to be penalty payments that are assessed under Torah law. They actually lost the authority to impose those payments. So basically, bottom line is that rabbinic courts can assess penalties, can assess, can make a party liable to have to pay money. But basically, that's going to happen either because the person caused a financial loss to the other party and now will be making restitution of that loss, or because the two parties have both submitted to the authority of the court that it might not otherwise have, or because the court can impose a judgment under threat of excommunication from the Jewish community. They can't put you in jail, but if a Jew is removed from a Jewish community, it means that no one in that community will do business with him. And particularly at certain periods of history where the Jews could rely only on each other and not on the rest of the people around them, that kind of an excommunication would have quite a bit of force indeed. So let's continue this discussion. But remember that this idea that the courts in Bavel, meaning courts outside of Eretz Yisroel, when there was that kind of authority and ordination, so that includes all the courts since then, lack this power to impose penalties, certain kinds of penalties, like the fourfold and fivefold penalty, that a thief of an ox that then sold or slaughtered would pay. That kind of penalty is not assessed. However, even though the court could not impose such a penalty, if the plaintiff in the case, right, the one who was injured, if he seized the property himself, if he took the matters into his own hand and seized the property of the one who caused him the harm, then as long as the seizure sort of conformed with the amount of money that would be payable under Torah law as a penalty, then the court won't step in and force the plaintiff to give it back, right? They won't take the money from the defendant and give it to the plaintiff, but if the plaintiff takes it himself, the court won't force him to give it back. So that's a little bit of background for this discussion. It's not collected. Right, and the Gemara notes that Rava conforms to his standard line of reasoning. As Rava says, compensation for damage to an ox caused by an ox, and for damage to an ox caused by a person, these kinds of damages are collected by courts in Babylonia. But compensation for damage to a person caused by another person, and for damage caused to a person by an ox, these are not collected by courts in Babylonia. So the Gemara clarifies, what is different about compensation for damage to a person caused by a person and damage to a person caused by an ox, that it is not collected in Babylonia? If you say that we require ordained judges to collect damages, and there are not any ordained judges in Babylonia, well then so too in a case of damage caused by an ox to an ox and damage caused by a person to an ox, say that we require ordained judges, and there are not any ordained judges in Babylonia. Now we're on page 84b. Rather, what is different about damage to an ox caused by an ox and damage to an ox caused by a man, so that Babylonian judges can rule in these cases, even though they are not ordained? The difference is that we, the judges of Babylonia, perform the agency of the judges of Eretz Yisroel, of the land of Israel, just as we do with regard to the laws of admissions and loans, as we are permitted to rule in those cases. Why? Because we're ruling as agents of the ordained judges in Eretz Yisroel. So if so, then in cases of damage caused to a person by a person, and cases of damage caused to a person by an ox as well, why not say that the judges of Babylonia perform the agency of the judges of Eretz Yisroel, just as it is with regard to the laws of admissions and loans? So the sages state with regard to this distinction, when we, the judges of Babylonia, perform the agency of the judges of Eretz Yisroel, right, acting as their agents, we do so in matters where the ruling is clear to us. But in matters where the ruling is not clear to us, such as in the case of an injury to a person, which requires an appraisal, we do not perform the agency of the judges of Eretz Yisroel. So the sages, it's not that we do it when we're not confused, but we don't make a ruling when we are confused. It's not about confusion of the judges when it says that when it's clear to us or when it's not clear to us. Rather, there are practices here that would clarify a case, but that are not permitted to be done outside of Eretz Yisroel. So it cannot be clear to us, and that's why we don't give rulings in those kinds of cases. So the sages, so the sages state an objection. In cases of damage caused to an ox by an ox, and damage caused to an ox by a man, cases that we do judge in Babylonia, the ruling is also not clear to us, as the damage must be appraised. Right? We don't know exactly what it is until it's appraised. So rather, how is the judgment assessed in those cases? We say, go out and see how much an ox is sold for in the marketplace, and thereby assess the value of the damages without a detailed appraisal. So if so, in the case of damage caused to a person by a person, and damage caused to a person by an ox, we should also say, go out and see how a slave is sold in the slave market. Why then are these latter cases not judged in Babylonia? And furthermore, in the case of payment of double the principal, which is incurred by a thief, and in the case of the fourfold or fivefold payment incurred by a thief who stole a sheep or an ox and then slaughtered or sold the animal, where the payments are fixed and there is no need for an appraisal, we should perform the agency of the judges of Eretz Yisroel. And the sages state, with regard to the distinction, when we perform the agency of the judges of Eretz Yisroel, we do so only in cases where the guilty party pays monetary restitution for a loss that he caused. But in cases of a penalty, such as the double, fourfold, or fivefold payments of a thief, we do not perform the agency of the judges of Eretz Yisroel. And the Gemara asks, in cases of damage caused to a person by a person where the liable party pays monetary restitution, should we perform the agency of the judges of Eretz Yisroel? And the Gemara answers, when we perform the agency of the judges of Eretz Yisroel, we do so only in cases that are common. Therefore, in cases of damage caused to a person by a person, cases that are uncommon, we do not perform the agency of the judges of Eretz Yisroel. And the Gemara challenges, but accordingly, for indemnities paid to a woman for humiliation and degradation after being raped or seduced, a case that is common, we should perform the agency of the judges of Eretz Yisroel. And the sages say in response, indeed, we do collect compensation for humiliation and degradation here in Babylonia, as Rav Papa collected 400 dinars as compensation for humiliation when he judged these cases. And the Gemara questions this explanation. But the other sages do not agree with the ruling of Rav Papa, as Rav Chisda sent this question to Rav Nachman, asking if he should collect compensation for humiliation and degradation. And Rav Nachman sent him the following reply: Chisda, do you collect a penalty in Babylonia? Meaning, we don't collect penalties in Babylonia. We only step in to make restitution of financial loss in common cases. So rather, explain the distinction this way. When we perform the agency of the judges of Eretz Yisroel, we do so only in a matter that is common and involves, i.e. the payment is for, a monetary loss. But in a matter that is common but does not involve monetary loss, or like humiliation or degradation, right? It's not a monetary loss. Or in an uncommon matter which does involve monetary loss, then we do not perform the agency of the judges of Eretz Yisroel. Therefore, in a case of an injury caused to a person by a person, even though it involves a monetary loss, since it is uncommon, we do not perform the agency of the judges of Eretz Yisroel. In a case of humiliation, even though it is common, since it does not involve a monetary loss, we do not perform the agency of the judges of Eretz Yisroel. So the Gemara challenges the law itself. But is it in fact the case that the courts in Babylonia collect restitution for damage caused by an ox to an ox? But doesn't Rava say if an ox caused damage, the courts in Babylonia do not collect the compensation? And the Gemara clarifies, to whom did the ox cause the damage? If we say that it damaged a person, Why did Rava specifically state his law in a case where there is an ox that damaged a person? Even in a case of a person who damaged a person, which is more common, the court does not collect the compensation in Babylonia. Rather, it is obvious that Rava meant that the ox damaged an ox. And Rava teaches the court does not collect the compensation in Babylonia. And the sages say in response, there, Rava stated his ruling with regard to an innocuous ox, right? Which we learned those laws at the beginning of our journey through this tractate when we were making a distinction between an innocuous ox, meaning an ox that has not gored other animals before, and a forewarned ox, an ox that has a history of goring. And now the owner has been put on notice. And if his ox gores again, he's going to be liable to twice as much in damages, and the damaged party is going to have recourse not only to the ox that caused the damage for the damages, but even to the superior quality property, even land, of its owner. Right, so this Rava stated his ruling with regard to an innocuous ox, i.e. an ox that was not forewarned, whose owner pays for the damage as a penalty. And penalties are not collected in Babylonia. Here, Rava states his ruling with regard to a forewarned ox, and payment for damage it causes is not a penalty, but rather it is compensation for the actual injury caused. And the Gemara challenges, but doesn't Rava say there are no forewarned oxen in Babylonia, as an ox can be forewarned only by ordained judges? And the sages say in response, this is a case where an ox was forewarned there in Eretz Yisroel, and then its owners brought it here to Babylonia. And the Gemara objects, but this is an uncommon matter, as forewarned oxen are not frequently transported from Eretz Yisroel to Babylonia. And with regard to an uncommon matter, did you not say that we do not perform the agency of the judges of Eretz Yisroel? So the Gemara answers, this is a case where the rabbis from there, i.e. Eretz Yisroel, who are ordained, came and declared this ox forewarned here in Babylonia. The ox didn't go to Israel. The ordained judge from Eretz Yisroel came to Babylonia. And while he was there, he determined that the ox was a forewarned ox, and the warning was given to its owner. So the Gemara challenges this interpretation. Ultimately, that is still an uncommon matter. And you say that with regard to uncommon matters, we do not perform the agency of the judges of Eretz Yisroel. So rather explain that when Rava says that courts in Babylonia collect restitution for damage caused by an ox, he means with regard to damage in the categories of eating and trampling, which are forewarned from the outset. Meaning that all agree that since these are common forms of damage and involve monetary loss, the judges of Babylonia perform the agency of the judges of Eretz Yisroel, and they collect compensation for the damage. Now, the Gemara returns to its discussion of our MIshna, the MIshna number 1 here in chapter 8, which states, how is payment for pain assessed? If one burned another with a skewer or with a hot nail, or even if he burned him on his fingernail where he would not cause a bruise that would affect the victim's value on the slave market, but yet he caused him pain, so the court evaluates how much money a person with a similar threshold for pain as the victim is willing to take in order to be made to suffer in this way. It's a strange way to measure, but the amount of pain that you caused me, how do we assess its value? Well, you have to find somebody who's similar to me in terms of threshold for pain and say to that person, how much would I have to pay you to inflict that degree of pain on you? That's the amount of money that your pain is worth. So the Gemara comments, this teaches that even when the pain is not in a place that causes damage to the injured party, the one who caused the injury must pay compensation. So the Gemara asks, who is the Tana who taught this statement? And Rava said this is the opinion of Ben Azai, as it is taught in a baraisa with regard to the verse kvia for kvia, meaning a wound for a wound, and habura for habura from Exodus 21:25. And Rabbi Yehuda Hanasi says a burn, kvia, is the first term stated in the verse, And Ben Azai says a bruise, habura, is the first term stated in the verse. And the Gemara explains the Baraisa. Ben Azai certainly agrees that the first term in the verse, kvia, means a burn. And with regard to what do they disagree? And Rabbi holds, Rabbi Yehuda Hanasi, who is known as Rabbi, holds that kvia indicates an injury that does not leave a bruise, and that one would be liable to pay for injuring another even in that manner. Therefore, when the Merciful One writes in the Torah, habura, it is to reveal about the meaning of kvia, that if the burn also has a bruise, then yes, the one who caused the injury must pay compensation for pain. But if the burn has no bruise, then no, the one who caused the injury does not pay compensation for the pain alone. And Ben Azai holds that kvia indicates a burn that also has a bruise, and that one would be liable to pay for injuring another only in that manner. And therefore, when the Merciful One writes in the Torah habura, it is to reveal about meaning of kvia that even if it is a burn with no bruise, the one who caused the injury must pay compensation for pain alone, even though there is no damage. No permanent damage. So Rav Papa objects to Rava's explanation of the Baraisa. On the contrary, the opposite stands to reason. As Rebbe says, a burn, kvia, is the first term stated in the verse, since he holds that kvia indicates a burn that also creates a bruise, and one would be liable to pay for injuring another only in that manner. And therefore, when the Merciful One states in the Torah habura, it is to reveal about the meaning of kvia that even if it is a burn with no bruise, the one who caused the injury must pay compensation for pain alone, even though there is no damage. So Rav Papa continues, and Ben Azai says that a bruise, a habura, that's the first term in the verse, and he holds that kvia indicates an injury with no bruise, and that one would be liable to pay for injuring another, even in that manner. Therefore, when the Merciful One writes in the Torah habura, it is to reveal about the meaning of kvia, that if the burn also has a bruise, then yes, the one who caused the injury pays compensation for pain. But if it doesn't leave a permanent mark, then no, he doesn't pay compensation for pain alone. And according to this explanation, the statements of Rebbe and Ben Azai with regard to the meaning of the terms in the verse are based on their final understanding of the verse. So, because when they say the first term stated, I mean, the Torah has not changed since Mount Sinai. So how could they be arguing about which word comes first? So what is it that they really mean? The first term stated, this phrase is referring to the understanding of the first term after the second term has been written, not what the understanding of the first term would have been if not for the addition of the second term. So according to the explanation of Rav Papa, the MIshna here is in accordance with the opinion of Rebbe. Right? In other words, it seems like one thing, and if it had been left like that, that's how we would have understood it. But then there's an additional term included, which comes, to alter our understanding of the first term. So then that's the way it works. Or are we saying, well, that new phrase comes, but this first term stays in its place, right? That's what they're arguing about. So the Gemara offers another explanation of this dispute between Rebbe and Ben Azai. Alternatively, everyone agrees that kvia indicates an injury whether there is a bruise or whether there is not a bruise. And here, Rebbe and Ben Azai disagree over whether the hermeneutical principle of a generalization and a detail is applied with regard to a generalization and a detail that are distant from each other. When a generalization is followed by a detail, the law applies only in the case specified in the detail. And the verse states, kvia for kvia, a wound for a wound, habura for habura. So the word kvia, as stated in the beginning of the verse, is a generalization that includes burns not accompanied by bruises, as well as burns accompanied by bruises. Habura, as stated at the end of the verse, is a detail of a burn that is accompanied by a bruise. So the Torah distances the detail, habura, from the generalization kvia by stating the law of a wound for a wound between them. So Rebbe holds that since there is an intervening phrase, we're actually on page 85a now, just getting a little bit of a start on this page, but I'm relatively near the end, so if you've got questions or comments, please get them in. So Rebbe holds that since there is an intervening phrase between the generalization and the detail, one does not derive the law from the verse concerning burns and bruises by employing the principle of generalization and detail. Therefore, the one who caused the injury is liable to pay compensation for pain in all cases of burns, even those that are not accompanied by bruises. And Ben Azai holds that one does derive the law from the verse concerning burns and bruises by employing the principle of generalization and detail, and therefore the one who caused the injury is liable to pay compensation for pain only if the burn is accompanied by a bruise, right? So what they keep arguing about is, it says wound for wound. What does it mean? Are we talking about a wound that looks like a wound, right? Whether it leaves permanent damage or not, that's actually debatable. But sometimes something causes pain and just doesn't leave a mark at all. Are we going to charge damages, to the one who inflicted the pain when it just didn't even leave any kind of a mark? Or are we only going to assess those kinds of damages when it did leave a mark? And if you would say, according to the opinion of Rebbe, why do I need the Torah to state the law of habura for habura, as that is included as a subset of kvia? In other words, these words, kvia and habura, right, they're kind of like technical terms. They both mean a kind of wound, but one leaves a mark and one without. So the phrase mentioning habura is necessary to teach the law of additional money, i.e. in a case where someone caused a burn with a bruise, he pays additional compensation for the bruise beyond that for the burn. Now, the MIshna teaches, how is the payment for pain assessed? The court evaluates how much money a person with a similar threshold for pain as the victim is willing to take in order to be made to suffer in this way. And the one who burned the victim must then pay this amount. And the Gemara asks, how do we appraise pain in a case where the injured party also suffered personal injury? So Shmuel's father says the court evaluates how much money a person is willing to take to allow someone to sever his hand, right? So instead of saying, well, a person without a hand, how much less is he worth if he's being offered as a slave on the slave market? Rather, we start to use this same process as, well, how much money is the pain that you suffered worth? Well, we ask somebody who's similar to you, how much money would we have to give you for you to endure that same kind of pain? Okay, why don't we apply the same principle to the loss of a hand? How much money would I have to pay you for you to give up your hand? That's how much money a hand is worth. And the Gemara immediately objects. Do you really mean to sever his hand? Wouldn't the evaluation be not just for pain, but to include all 5 types of indemnity? Moreover, are we dealing with fools who would accept money to have their hands severed? Is there enough money in the world that you would take in order to lose your hand? And the Gemara answers, rather, the court evaluates how much money a person would accept to allow someone to sever his already severed hand, which is of no use, right? So in other words, he's got a hand there, but it doesn't work. Then how much would he have to take in order to have it removed? And the Gemara objects. In the case of his severed hand also, there is not pain alone, but there is both pain and humiliation, because it is an embarrassing matter for him if someone were to take a part of his flesh and throw it to dogs. And the Gemara answers, rather, the court evaluates how much a person is willing to take to allow someone to sever his hand, which is already condemned by a written decree from the government to be severed, changing the decree from having it severed by means of a drug, which is not accompanied by pain, to having it severed by means of a sword, which is accompanied by pain. Right? Now you can see that the sages are definitely now moving over into the realm of the extreme hypothetical type of circumstances, just to get at their understanding of what are we actually saying here, and creating a case that could, fit within parameters from competing areas of the law. Right? So you're not going to take somebody's hand, but you have to assess the damages for someone who caused an injury that involved the loss of a hand. How are you going to measure that amount of money? So now the suggestion on the table is, well, no one would volunteer to have his hand severed. But since they live, right, in a place that they have to subject themselves to the law of the land, right? So they lived in the Babylonian Jewish community, was subject to the laws of the Persian Empire. And in the Persian Empire, taking someone's hand was indeed a penalty that the government would mete out, presumably for a convicted thief. So, if you had been convicted of thievery in a Persian court, and you were going to have your hand taken from you, but the government, I guess, sort of like a modern government that, when they have to impose the death penalty, seeks to do that in a non-painful way. Okay, so the Persians had some kind of a method where with no pain, they would remove a person's hand. So how much would you have to pay a person for them to volunteer to submit to have the hand removed, not by the painless way of the Persian government, but rather by having a sword, an axeman come in and hack it off with a sword. So that he's going to lose the hand anyway, but how much extra money would he have to receive in order to have it done in that painful way? That's how we're going to assess the loss of a hand, or at least the pain that accompanied the loss of a hand. Where am I? So the amount of money that he would accept to have his hand severed by a sword instead of by the drug, this would be his compensation. But the sages say in objection, here too, one would not take money and cause himself pain in this way. So there is no indemnity to evaluate. I mean, I'm not sure that that's true. I think somebody who is going to lose his hand anyway might take money if it was a sufficient sum. But they're saying this is not how we're going to assess damages. This doesn't make sense. So let's look for a different way. So the Gemara answers, rather, the court evaluates how much a person would have to give someone to sever his hand, which is already condemned by a written decree from the government to be severed, changing the decree from having it severed by means of a sword, which is accompanied by pain, to having it be severed by means of a drug, which is not accompanied by pain. And the Gemara objects, well, if this is the case, then this wording of the Mishnah, to take, is imprecise. It should have said to give. So Rav Huna, how much would he have to give in order to have his hand severed in a pain-free way? Right? The government was going to do it with a sword. How much would he have to bribe some Persian judge to have his hand removed the painless way rather than the painful way? Maybe that's the amount of damages. And Rav Huna, the son of Rav Yehoshua, said the Mishnah means that the court evaluates how much this one, the injured party, will take from that one, i.e. the one who caused the injury, based on what this man, the injured party, would have given to the government to have his hand severed by a drug rather than with a sword. Now, these are all kinds of backflips that they are turning to try to come up with a number, but, I mean, you could see the difficulty. Right? When assessing what is a hand worth, or what is the pain worth that accompanies the loss of a hand, and we're not talking about loss of livelihood. Somebody was a surgeon, he lost his hand. That's a different measure, right? Here we're just talking either about damage or about the pain that accompanies the damage. And it's not an easy number to pin down, so the sages doing all these kind of mental gymnastics, it makes some sense when they're trying to come up with what is that number going to be. At the end of the day, no number is really going to be satisfactory. I mean, different pain is measured different ways. No one can really understand the pain of another person, etc. But the lack of being able to come up with a number satisfactory to everybody is not going to stop them from coming up with some kind of a number so that at least an attempt to create justice can be made. Okay. Let's take a few comments or questions on Bava Kamma 84. Joe, when a judgment is given, how long does the responsible party have to pay it? Are payments allowed, or is the judgment required to be a one-time payment? I don't know. I think, first of all, this is going to be different when we're talking about, a rabbinic court, which was very much, the go-to place for any kind of litigation among Jews in the Jewish community. They didn't want to end up in a Persian court, if at all possible. And, today, Jewish communities are not so, what's the word that I'm looking for? They're not so cohesive, right? And sadly, Jews will litigate against other Jews all the time, in American courts or Russian courts or French courts or British courts. And it's not always that they're taking their business dealings to a rabbinic court. I mean, rabbinic courts are certainly used in cases of divorce, and because a get has to be given. There's some matters that are always going to go to rabbinic courts. And then you also have, where you have in a religious Jewish community, there's some kind of an issue that comes up between businessmen, and they submit to the authority of the court, a little bit like arbitration, where people submit, to the ruling of the arbiter. And that's a little bit of a different thing. And then I guess in terms of, how long they have to make good on a judgment that's issued by the court, it's just going to be part of, the agreement to submit to its authority. And I don't know, what those rules are offhand. Ilan, it says, Sal and Nina, I am starting off this week with introducing a local rabbi to AT Daily and your film career. Still looking forward to the release of Man in the Long Black Coat. All the best. We're getting closer. Just for a little report on where we are with our movie. Post-production just always takes a long time. And it's almost like the really, you can go 95% of the way there in a certain amount of time, and that last 5% can take just as long, right? And so it's those little crucial refinements at the end that require little visual effects nudging, or in this case, working with the composer and getting the music just right. But we really are near the end of that, and then we're going to lock picture. Then we can finally do the sound effects editing and the color timing of the movie. And then, because it's an independent movie, then we'll begin shopping it in its finest form, to the distributors to get the right distributor for this picture. We're very excited about it, and we want to work with the right partner. So we'll keep you apprised as to the progress. That's what I've got for us tonight. And with God's help, we'll be together again tomorrow, Sunday, at the regular time, 6 p.m. Pacific, for page 85 here in Tractate Bava Kamma. Have a great night and a good week. Shavua Tov. Good vach.